I knew something was wrong the moment I heard the pop. Not a loud explosion, not a crash, just a sharp, violent snap under my tires. Then another. By the time I stopped the truck, both front tires were hissing air into the cold mountain air. And that's when I saw them. Spike strips across my own driveway. But here's the part that didn't make sense. This wasn't just some random vandal. There was a sign. Bright orange, hand-painted. Private access. Trespassers will be prosecuted. Signed with my neighbor's name. The same neighbor who, apparently, had decided my mountain cabin now belonged to him. I bought the place 5 years ago. 2 acres, bordered by national forest on one side. A gravel access road that had existed longer than either of us had been alive. Quiet, peaceful, off-grid. The kind of place you go to escape people. Which is why what happened next made 0 sense. Because you don't move to the mountains to start a turf war. Unless you're unstable. The problem started 3 months earlier. A new neighbor moved into the property downhill. Name, Carl. Retired contractor, mid-60s. Always wearing tactical boots. First conversation we ever had. You know this road actually cuts through my parcel, right? I laughed. Because it didn't. County maps were clear. The easement was recorded. Public access right-of-way to 3 cabins, including mine. Carl didn't laugh. I've been reviewing old boundary lines, he said. That was the beginning. 2 weeks later, a wooden post appeared near the fork in the road. Then another, then a chain, then a padlock. Blocking the lower portion of the shared access trail. I drove around it at first, thought maybe he was doing maintenance. Then I saw the sign, private property, no access. That's when I checked the county records again. Nothing had changed. But something had changed in Carl's head. I walked down to his place. Calm. Non-aggressive. Hey, that road is recorded access for my property. He didn't even invite me onto his porch. You're mistaken. I'm not. I've had a survey done. Great. Show me. He refused. Said it was pending review. That's when I realized this wasn't confusion. This was escalation. The chain became a gate. The gate became reinforced. Then came cameras. Then came motion sensors. And then, the spike strips, placed just beyond a bend in the gravel path, where you couldn't see them until it was too late. That's where my tires died. And that's when I stopped playing polite. Cell service in the mountains is unreliable, but I got through. Deputy arrived an hour later. Looked at the strips, looked at the sign, looked at me. Is this your access road? Yes. He walked the path, found the recorded easement marker, radioed it in, confirmed. Carl had no authority to block it. Then the deputy said something interesting. Spike strips can be considered hazardous obstruction. Hazardous. That word mattered, because now this wasn't just a property dispute. It was a safety issue. When the deputy knocked on Carl's door, he came out defensive. They've been trespassing for years. Deputy asked for documentation. Carl handed over a folded survey map, hand-drawn notes in red marker, lines adjusted, boundaries shifted. The deputy looked unimpressed. This isn't filed with the county? Carl insisted he was correcting an old mistake, but you don't correct mistakes by flattening someone's tires. Deputy ordered immediate removal of the spike strips. Carl protested. Deputy stayed firm. You're creating a hazard on a recorded easement. Carl glared at me like I'd betrayed him, like I was the invader. That night I replaced my tires in freezing weather, and I knew something. This wasn't over. People who invent boundaries don't let them go easily. 2 days later, I found something else. Large boulders placed along the side of the trail, not blocking fully, just narrowing it, enough to make it difficult. Petty, calculated, a psychological tactic. Carl wasn't just claiming land, he was trying to exhaust me, so I hired a licensed surveyor. Not a hand-drawn map, not a backyard guess. Official, filed, stamped. 3 weeks later, we had clear markers placed, bright orange flags, metal stakes, Coordinates documented. The easement was exactly where it had always been, and it cut straight across the edge of Carl's parcel. Legally, recorded, enforceable. When Carl saw the survey crew, he lost it. Accused them of fraud. Claimed collusion. Threatened to sue everyone involved. The surveyor calmly handed him a copy. With filing reference numbers. Carl ripped it in half. Which legally means nothing. Because copies exist. Many copies. Then came the final escalation. The second set of spike strips. This time hidden deeper. Not visible. Designed to damage. And that's when the deputy stopped being patient. Because intent matters. One strip might be stubbornness. 2 strips after official warning? That's deliberate endangerment. When I hit the second set of spike strips, I didn't even get angry. I just felt done. Because this wasn't a misunderstanding anymore. This wasn't about boundaries. This was intentional. The strips weren't even visible from the driver's seat. They were placed just past a dip in the gravel, positioned to shred tires at low visibility. That's not defensive behavior. That's premeditated damage. And this time, I didn't just call the sheriff. I filed paperwork. Same deputy responded. But his tone was different. He photographed everything, measured distances, logged the prior warning in his system. Then he said something that shifted the entire situation. This is now criminal mischief, possibly reckless endangerment. Carl had crossed from civil dispute into criminal territory, and mountain communities don't tolerate hazards on shared access roads, especially roads emergency vehicles may need. Carl was cited, not arrested yet, but formally charged with criminal mischief, obstruction of legal easement, creation of a hazardous condition. He didn't take it well. He started shouting about sovereign land rights and government overreach. When someone starts using phrases like that in a property dispute, it's rarely a good sign. I wasn't going to wait for round 3. My attorney filed for an emergency injunction. Purpose? Force removal of all barriers. Prohibit interference with recorded easement. Establish financial damages for destroyed tires. The hearing was set fast. Mountain County courts move quickly when access roads are involved. Because access roads aren't just convenience, they're safety corridors, fire trucks, ambulances, evacuation routes. Carl wasn't just blocking me. He was interfering with infrastructure. Small courtroom, wood-paneled walls, 8 people in attendance. Carl showed up carrying a massive binder, tabs sticking out everywhere. He looked confident, too confident. Judge opened calmly. Mr. Carl, this is a recorded easement dispute with accompanying hazard complaint. Carl interrupted. It's fraudulent mapping. Judge didn't react, just adjusted glasses. Do you have a filed survey contradicting the county record? Carl handed up his hand-marked document, red ink everywhere. Judge stared at it for a full 5 seconds, then looked at him. This is not filed with the county recorder. Carl tried to argue historic land shifts, old timber routes, mineral rights. The judge stopped him. Do you have a filed boundary adjustment? Silence. That silence said everything. Temporary injunction granted immediately. Carl ordered to remove all physical barriers, cease interference, avoid contact with me, allow unrestricted use of easement failure to comply, contempt of court, and contempt means jail. The judge also scheduled a follow-up hearing regarding damages. Carl's face changed, not angry, not loud, just shaken. Because now this wasn't personal anymore. It was judicial. He had 72 hours to comply. Day 1, nothing changed. Day 2, cameras on his property turned toward the road. Day 3, the gate was still there. My attorney didn't hesitate, filed a motion for contempt. Deputy returned with paperwork in hand. When Carl saw the deputy again, something snapped. He started claiming harassment, conspiracy. Said the entire valley was against him. The deputy stayed calm. You were ordered to remove the obstruction. Carl refused, so they removed it for him. County-authorized crew arrived, cut the lock, removed the gate, loaded it onto a flatbed. Carl stood there filming on his phone, yelling about lawsuits, threatening federal claims. But here's the thing about court orders. They don't care about volume. They care about compliance. And Carl was officially non-compliant. It happened quietly. No dramatic tackle. No sirens. Deputy walked up, explained contempt violation, placed him in cuffs. Carl kept saying, "This is my land." Deputy responded calmly, "The easement is recorded." That sentence ended the debate. Mountain communities are small. News spreads fast. By the time Carl made bail, everyone knew. And here's what made it worse for him. Other property owners started reviewing their access maps. Turns out, Carl had attempted to adjust boundaries with 2 other neighbors in past months. He had been slowly redrawing reality in his favor, and people were tired of it. Follow-up hearing came 2 weeks later. I submitted tire replacement receipts, tow costs, legal fees, survey expenses, judge-awarded full damages, plus court costs, plus warning that continued interference would escalate penalties. Carl tried one last argument. "I was protecting what's mine." Judge responded, "You cannot protect what is not legally yours." That line hit hard. You'd think that would end it, but it didn't. Because 3 days after the hearing, I received a letter from Carl's bank. Foreclosure notice. Apparently, legal fees weren't his only financial strain. His property had been leveraged heavily, and mountain land isn't cheap. The stress had been building long before me. I wasn't the cause. I was just the trigger. One night, a week after his release, I heard something unusual. Engines. Multiple. At 2 a.m., lights moving along the tree line. I stepped outside with a flashlight and saw something that made my stomach drop. Heavy equipment near the lower ridge, on Carl's property, and the direction they were facing? Toward the easement road. 2:07 a.m. Mountain nights are silent. No traffic, no streetlights, just wind and trees. So when I heard engines grinding through the dark, I knew it wasn't normal. I stepped onto the porch. Down below, near the lower ridge, headlights, heavy equipment, a bulldozer, and it was positioned directly toward the easement road. My road. By sunrise, it was clear what Carl had tried to do. He couldn't block the easement legally, so he tried to eliminate it physically. The bulldozer had pushed earth sideways, creating a dirt berm across part of the gravel path. Not fully destroyed, but damaged, rutted, narrowed. If left unchecked, one hard rainstorm would wash it out completely. It was sabotage disguised as land grading. I called the sheriff immediately, not just for obstruction, but because heavy equipment altering shared access routes without permits is a serious violation in mountain counties, especially near protected forest areas. Deputy arrived again. Different tone this time. No patience left. He examined the grading marks. Tire tracks matched equipment parked on Carl's parcel. He asked the question plainly. "Did you authorize excavation near the recorded easement?" Carl's response, "I'm improving drainage." At 2 a.m., without permits, without notification, on a legally protected access corridor. The deputy didn't argue. He just started writing. Here's something Carl didn't consider. Mountain roads often fall under erosion control guidelines. Any grading near forest boundary land requires review. The dirt he pushed? It partially redirected runoff toward a protected slope, which meant now this wasn't just civil. It was environmental violation territory. County inspector showed up within 24 hours, issued a stop work order, documented soil displacement, estimated remediation costs. Carl looked stunned. He thought he was fighting a neighbor. He accidentally picked a fight with the county. At this stage, Carl wasn't yelling anymore. He looked tired, unshaven, paranoid. He accused the county of targeting him. Said I had influence. I didn't. The only thing I had was paperwork, recorded easement, filed survey, court injunction, sheriff reports, environmental documentation. When facts stack up, conspiracy theories collapse. Then came the real blow. 30 days after the injunction hearing, his foreclosure finalized. The bank posted notice on his door. Apparently, legal fees, court fines, environmental remediation estimates, missed payments. It was too much. The mountain property he tried so hard to protect was no longer his. And here's the twist he never saw coming. Mountain foreclosures don't sit long. Land like that attracts interest. Hunters, retirees, remote workers. But this time, the buyer was someone I already knew. A retired fire captain from 2 cabins up. Level-headed, calm, practical. The kind of neighbor who brings extra fuel during snowstorms. He closed within weeks. And the first thing he did? Knocked on my door. Let's make sure the easement is clearly marked and protected. That was it. No ego, no annexation dreams, no spike strips, just mutual understanding. County required full road restoration. Bulldozer damage reversed, gravel relayed, drainage corrected. Carl's bank covered the remediation through asset liquidation. Irony at its finest. The same road he tried to erase ended up more reinforced than ever. Wider, stronger, properly graded, officially documented. He tried to remove it. He made it permanent. Moving day was quiet. Small trailer, few boxes, no eye contact. He didn't glare, didn't rant, didn't accuse. He just looked defeated. Because the truth is, he didn't lose to me. He lost to documentation, to law, to reality. There's something about mountain living. It demands cooperation. You don't survive harsh winters by creating enemies on access roads. You don't call emergency services easily. You don't escalate over ego. Because isolation magnifies consequences. Carl treated land like territory, like conquest. But property ownership isn't about domination. It's about responsibility. And responsibility requires boundaries. The real ones. Filed, recorded, enforced. I learned something important through all of this. Never argue with unstable behavior. Document it. Never escalate emotionally. Escalate legally. And never underestimate how fast someone's pride can bankrupt them. Because that's what really happened. Not revenge, not victory, just consequences catching up. The road is quiet again. Gravel crunches softly. No chains, no spike strips, no midnight bulldozers. The easement sign now has a small reflective marker, placed there by the new neighbor. Clear, visible, undeniable. Sometimes peace doesn't come from fighting harder. It comes from standing firm and letting the system do its job.